coming out. Okay.
I mean, if not, it's gonna be posted.
Yeah,
so
later. Yeah,
a
let's
ton
be
of people saw it
positive.
after. I think last time we only had like a dozen people showing live, but then it was like over 200 views right off.
All right. Thanks, everybody. We're back live. I think the link stayed the same. So thanks for being patient with us as we figured that out.
Awesome.
Awesome.
All right, thank you. For anybody who joined us earlier, this is going to be redundant, but just so we have a full record here, I'm going to start all over. My name is Diane Nguyen. I use she, her pronouns. I am a staff attorney with Legal Aid Services of Oregon, the Portland Regional Office, and I'll let Mateo introduce himself.
Awesome. Hey everyone, my name is Mateo Ermida. I use he, her pronouns, and I am a housing paralegal and outreach worker at the Portland Regional Office for Legal Aid Services of Oregon.
So thank you to Don't Shoot PDX for allowing us this space here to talk to folks today about some eviction, basics, COVID-19 tenant protections, and eviction expungement. Before we get into the substantive part, discussing the law, just want to give a little more introduction about our organization. Legal Aid Services of Oregon is a nonprofit organization with 8 regional offices statewide, and we provide free legal help to low-income Oregonians. The office that Mateo and I come from, the Portland Regional Office, serves 5 counties: Clackamas, Hood River, Multnomah, Sherman, and Wasco County. Other than housing cases, a bulk of our practice is doing family law cases. We also do senior law issues, government benefits issues, consumer issues, and employment issues. Depending on your local legal aid office, the practice area might be a little different, but that's the general capture of the type of practices that legal aid offices engage in. And aside from the local offices, we have 4 statewide programs: the Farm Worker Program, Native American Program, a statewide tax clinic, and a wildfire disaster relief program. We also run 2 statewide hotlines: a wildfire disaster relief hotline that was established late last year in response to the wildfires that caught all of Oregon around September. And then there is also a statewide public benefits hotline. Okay, moving from that introduction into the substantive area, just to give folks an overview of what we'll be covering today. There are 3 main topics we'll be covering today. First, we'll talk about eviction basics so that we're on the same page when we're talking about terminology and the concepts that we'll cover later on when we're talking about the specific protections, COVID-19 protections. So that portion of eviction basics, we'll start by talking about the general eviction process and timeline. We'll discuss some basic requirements for a landlord to evict a tenant, and we'll talk about different types of notices so that folks kind of have an idea of what to look out for when they are potentially facing an eviction. The key takeaway from this portion is that evictions must comply with strict legal requirements. Don't feel compelled to remember everything that we're discussing today, but the key takeaway for you here is when you find yourself potentially facing an eviction as a tenant is to find out, what are my legal rights? Second main topic we'll be talking about is COVID-19 protections. We'll talk about the laws that have been enacted at the state, local, and federal government levels that provide protections for tenants during this time of exacerbated eviction crisis due to the global health pandemic. The key takeaway from this portion will be that tenants should apply for rent assistance as soon as possible. Rent assistance is available, and a lot of to maximize your protections, you should apply for rent assistance as soon as possible. And last, we'll have a brief portion on eviction expungements, which is expungement, or the erasure of your eviction records, is a really powerful tool that, due to recent changes at the state level, has become much more accessible to tenants. So we want folks to know that that is available and is a fairly straightforward process. So tenants should really take advantage of this opportunity to clean up any eviction records in the event that prospective landlords are looking at that history. All right, so moving into our first substantive topic here, take you through what the general eviction process looks like. For a landlord to evict a tenant, it must start with the landlord issuing to the tenant a written physical document, and that is a termination notice. They serve it on the tenant, and once the tenant receives it, the basic options for a tenant then is, do I settle, reach an agreement with the landlord, and I continue staying? Or do I move out before the termination date? or do I stay past the termination date and decide to fight this eviction in court? So Mateo will discuss in later slides. These termination notices must be given to tenants or must be served to tenants in certain ways, and they must contain certain information. So a tenant who receives a termination notice or finds himself in that situation, potentially facing an eviction, first instinct should be, what are my legal rights? Find that out and find out whether their landlord is complying with their legal obligations. So the second step of the eviction process, if the tenant stays past the termination date, is the landlord can now file an eviction case in court. Just take a step back to make sure to distinguish. Oftentimes we hear folks use the term eviction notice. That is confusing and sort of a conflation of actually two different ideas. It's the termination notice, which is the document that the landlord serves. That does not involve the court process. And there's the eviction case that gets filed in court if the tenant does not move out by the date noted in the termination notice. So in Oregon, the only legal way to evict a tenant is for the landlord to obtain an order from the court. So when we say eviction judgment or eviction notice, sometimes it can, or if you say eviction notice, it can be confusing. Where are we in this process? Right? Part one, the termination notice been served, or part two, the eviction case haven't been filed and the summons haven't been served. So two, after the case gets filed here, is the options are basically the same. Again, is you can try to work out an agreement with the landlord. You can move out before step three, which is first appearance date, or you can decide to stay and fight the eviction in court. Step three is first appearance. Folks should keep that date in mind because that term does have relevance for the your tenant protection rights that we talk about later. First appearance is that first court date that a tenant has to appear at, and at the court, let the court know whether they have moved out. They're going to try to negotiate something with the landlord and ask for this case to be rescheduled, or they let the court know that we want to go to trial. If they decide to go to trial, we're on to step four. They have to file what's called an answer. So that's the document where they respond to the landlord's allegations. Landlord had filed a document saying that I have the right to repossess the premises here. The tenant, by the end of the day on first appearance date, must file the answer unless otherwise directed by the court. Once the answer is filed, the court sets the date for trial. If the parties don't reach some sort of agreement beforehand, at the date of trial, after the trial, if the tenant wins, they get to stay. If the landlord wins, the tenant would have 4 days to move out.
Awesome, thank you, Diane. So as Diane mentioned, I'm now going to cover some of the basics of termination notices, which again is just that first step in the eviction process. So this is before an eviction case has been filed. And yeah, I mean, termination notices vary, you know, it depends what information needs to be contained, and all that depends on what kind of termination notice it is, and we're going to cover that in subsequent slides. But first, we're going to talk about how these notices need to be provided to the tenant. So they're basically, under the law, there are 3 valid methods that a landlord can use to deliver a termination notice to their tenant. If they fail to adhere to one of these 3 methods, then the tenant may have a defense to the termination notice, and the landlord wouldn't be able to evict on it. So the first of these methods is personal delivery, which is basically just your landlord handing you the termination notice in person. The second method is first-class mail. In cases in which the landlord decides to issue a termination notice using this method, they need to add at least 3 days to any deadlines included in that termination notice, including the move-out date. And then lastly, we have what's called post-in mail. And post-in mail is a weird one because not all landlords can use it. Only landlords that included that as a valid method of delivery in the rental agreement when the tenancy began can use that as a way of delivering the notice to the tenant. And basically the reason that a landlord would want to do this is because when you post in mail, they don't need to add those 3 additional days to any deadlines included in the termination notice. And sorry, I don't believe I explained what post in mail means. Basically what it means is just the landlord posts a physical copy of the termination notice to the front entrance of the dwelling unit, or the home, wherever the tenant lives and rents from. And they also mail it to the tenant via first-class mail. So again, in order for them to not have to include those 3 additional days, that needs to be something that's included as a valid method of delivery in the rental agreement. And then in addition to that, like Diane mentioned, these notices need to contain certain information. So again, the information contained in these notices is going to vary depending on what kind of termination notice you've been issued. But in a general sense, all notices need to include at least an issue date, so the date that that notice is being issued to the tenant, a vacate date, so the date by which they need to move out, and if they don't move out by that day, they can go file an eviction against them. It also needs to include a disclosure for veterans, just letting them know that they have a right to seek out resources and providing information on that. And then depending on the type of notice, it also, in some cases, needs to provide a chance for the tenant to cure whatever violation is being alleged in that termination notice. And generally, the landlord needs to do two things if there is an opportunity to cure. They need to specify how a tenant might cure the violation included in the termination notice. And they also need to include information about the date by which the tenant needs to cure that violation. So I mean, in the case of a non-payment of rent termination notice, usually the tenant has the full extent of the termination notice period to pay back the rent, and that essentially is a cure in that case. When a tenant is first issued a for-cause termination notice for a material violation of the lease, generally tenant or landlords provide at least 14 days for them to cure, but in some cases that may vary. And then lastly, again, depending on the type of notice, in some cases a tenant might be entitled to relocation assistance. And we'll kind of touch on what kind of notices would trigger that obligation for landlords as well in later slides. So again, there are various types of termination notices. It's definitely more than 4, but we basically split them into 4 different categories, just to make it easier for folks to understand. So the first of these categories are no-cost termination notices. So generally, tenants who have lived in their current home for more than a year cannot be evicted without a reason. There is an exception that applies if the landlord lives on the same property and there are 2 or fewer units, so basically for small-time landlords. And the other thing to note is that no-cost termination notices, as many of you may remember from our previous presentations on this topic, were prohibited during the moratorium. So the moratorium, as you guys will later find out, is now expired. So those are allowed once again. And yeah, so that's the first category of termination notices. The second category is also kind of falls under the category of a no cause, but we call them landlord-based reason termination notices. So these are essentially notices that a landlord can issue. They're usually not related to a tenant's conduct. Basically, they can be issued for 1 of 4 reasons. So the first of these reasons is if the landlord plans on demolishing or converting the unit to a purpose other than for residential purposes. So let's say, for example, you live in a single family home in the city of Portland, and your landlord decides, hey, I want to convert that into a coffee shop or I don't know, a boutique store or something of that nature. They could issue you a 90-day termination notice, basically specifying that intent, telling you that you have 90 days to vacate. And in some cases, the tenant might have the entitlement to relocation assistance, and that needs to be specified in the termination notice as well. The second of the reasons why somebody might be issued this kind of termination notice is if the landlord plans on conducting repairs or renovations that will render the home unsafe to live in while those repairs or renovations are underway. A landlord can also issue this if the landlord or an immediate family member of the landlord plans to move in. And then lastly, a landlord can issue this kind of notice if a new buyer, if they've accepted an offer for the home from a new buyer, and that new buyer plans on using the home as their primary residence as well. And those kinds of termination notices generally were allowed during the moratorium. The third category is for-cause termination notices. So these are used to evict tenants for violating the rental agreement or the law. They're tenant obligations under Oregon Landlord Tenant Law. Throughout the moratorium, these were permitted. So yeah, again, the only thing I want to say about that is, there are different types of for-cause termination notices. There are what we call 3014. So those are those curable for-cause termination notices, where generally the landlords can give you 14 days to cure whatever violation there is. Generally after that, if the landlord alleges that you've committed a similar violation to the one specified in that first 3014, they can then issue you a second 10-day termination notice for repeat violations, and that one doesn't have to give you the opportunity to cure, and so on and so forth. There are other types, but those are the 2 main ones. And then lastly, we have non-payment termination notices. So technically, this is a subcategory of for-cause termination notices, right? Because technically, if somebody's not paying their rent, in a general sense, that entails a violation of the rental agreement and their obligations under the law. But as many of you know, because of the moratorium, because the legislature and Governor Kate Brown acknowledged that a lot of folks just weren't able to pay their rent for very valid reasons during the pandemic, those kinds of termination notices were generally prohibited during the moratorium.
Okay, now that we're kind of on the same page about the basics of evictions and the terminologies and concepts that are involved, we're going to move into our second category of the second main topic here, which are the COVID-19 tenant protections. These are the highlights of this portion, and we'll dig into them a little more, but just to give folks the highlights up front. As Mateo mentioned, Oregon's moratorium had ended. It ended at the end of June 30th, 2021. What that means is all the termination types that Mateo just discussed are now permitted again. So before, the no-cause non-payment terminations were not allowed, but they are all allowed now. However, despite those terminations being allowed, there are still some protections that exist, and these protections are all automatic. So before, under the previous law, House Bill 4401, folks might have heard the need to sign a declaration in order to qualify for the protections. That's no longer the case. For all tenants, they are now automatically protected. Another important thing to keep in mind as we discuss this is we'll be referring to an emergency period, and we'll be referring to back rent. And what that refers to is the emergency period is April 1st, 2020 to June 30th of 2021. So that is that emergency period, COVID-19 moratorium period. And when we refer to back rent, we're talking about rent that accrued during that emergency time period. So some of the other highlights of these protections is that the back rent, right? So rent that accrued during that emergency period, the due date for that is extended into February 28th of 2022. In later slides, we'll kind of break things down a little more so that folks don't feel like you have to kind of understand everything based on just these highlights here. Another main protection that we'll be discussing more is what's called the safe harbor rule, or law that at the state and local level have been enacted at the state level and then locally for Multnomah County. So what that is it allows a tenant who is facing a non-payment termination to initiate a 60 or a 90-day pause on that eviction, that termination process, if they have applied for rent and they've provided proof of that application to their landlord. We'll also discuss how the law has required that landlords must comply with certain new notice requirements when they issue a non-payment termination notice. So if they are not complying with some of those requirements, that could provide the tenant with a defense to the eviction. And lastly, we'll be talking about certain credit history and rental screening and eviction history and guest protections that have been put in place to provide additional protections to tenants during this really difficult time. Okay, so to break it down a little more, no cause, so all the termination types are allowed again, one of which is the no cause terminations. What that means is beginning on July 1st of 2021, landlords are again allowed to use a 30-day no cause notice to evict people who are living in the unit. They're still within the first year of occupancy, which means 1 year in that same dwelling. Additionally, because before, during the moratorium, the legislature had prohibited the use of no cause notices, they've now essentially established a 2-month window from July 1st of 2021 to August 31st of 2021 for landlords to use these no cause notices to evict those people whose first year of tenancy would have had expired during the emergency period, and the only reason that they could not have been evicted earlier was due to the fact that there was that moratorium. So there's that 2-month window that's been created for landlords. And the other thing we want to highlight with no cause terminations is that for Portland renters, there are additional rights attached to that. So a Portland renter who must get a 90 days notice, so more time than the rest of the state. And in certain cases, landlords must also pay relocation assistance to the tenant. The other big category of terminations that were previously prohibited but now allowed again, the non-payment termination notices. So beginning on July 1st of 2021, after moratorium lifted, tenants must now, starting the month of July 2021 moving forward, they must pay their rent concurrently or they will face termination. However, the law provides that landlords cannot give a non-payment termination notice until the eighth day of the rental agreement. So if rent is due on the 1st, which is the case for most renters, then the earliest that a landlord can issue a non-payment termination notice is on the 8th of the month. So as I mentioned earlier, tenants have until February 28th of 2022 to pay back the rent that had accrued during the emergency time period. And then until March 1st of 2022, landlords are not allowed to terminate for that back rent that accrued during the emergency time period. Landlords are also not allowed to sue for that back rent or to send that debt to collections. And in an attempt to balance out the really text-heavy slides I just went through, this is a sort of blurry picture to sort of depict this a little. So what we have in the Boston area there, April 1st of 2020 to June 30th of 2021, that Boston area represents that emergency time period. So all the rent that accrued during that time is not due until February 28th of 2022. And but for rent moving forward from July 2021 moving onward, that has to be paid according to the lease, and if not, would be grounds for a non-payment termination. And then that July, August, that's the 2-month window that I had mentioned, because during that emergency time period, landlords weren't allowed to use these no-cause notices. The legislature has created this 2-month window for landlords to be able to use them if they would have been able to otherwise, if not for the moratorium.
Awesome. So now I'm going to go into Senate Bill 278 and Multnomah County Ordinance 1296. So as I mentioned, essentially the big thing that these two pieces of legislation, I guess you could call them, did is that they created this safe harbor period. And so essentially another way of referring to this is like the 60 or 90-day pause on non-payment termination notices. So essentially what this means and what these laws provide is that tenants who apply for rent assistance and provide documentation of their application to the landlord cannot be evicted for non-payment of rent for 60 days if you're outside of Multnomah County, or 90 days if you reside within Multnomah County. And so basically that time period, that clock starts to tick from the date that the tenant provides the landlord with documentation. And so just something to highlight about that, generally, one of the things that we've been recommending to tenants is that, if you haven't received a termination notice yet, the eviction process hasn't started, there's really nothing to worry about. So if you have proof that you have applied for rental assistance and you fear that your landlord might issue you a termination notice, then one thing to consider is maybe waiting until you've been issued that termination notice. That way you just buy yourself as much time as possible to remain protected under these laws. So tenants may submit that documentation, that proof of rental assistance at any time before or during the eviction process, up to the end of first appearance. So as Diane previously mentioned, first appearance is, again, that first hearing that you basically go to when after an eviction case has been filed against you. And so again, essentially what tenants are obligated to do is they need to provide that proof of rental assistance by the end of that first appearance hearing. So that's very important. That's basically the last chance that they'd have to do that in order to exercise those protections. That documentation can be pretty much anything. It can be as long as it's in writing. So it could be an email, a screenshot, or other written or electronic documentation from the rental assistance provider that verifies that that tenant has applied for rental assistance. The tenant can submit that in any reasonable method, including by texting it to the landlord, emailing a copy of the photo to the landlord, delivering it in person, mailing it to them, whatever they wish to do. But again, it's just important that that be in writing and that you have some method of verifying, yes, I submitted that to the landlord. Here's the date that I submitted it, just in case that they try to, I don't know, finesse the law and try to claim that it was never submitted in the first place, and that they could proceed with eviction for non-payment. Another thing to note is that rental assistance providers must promptly provide a dated application receipt to each tenant who applies for assistance. And so that's one of those pieces of documentation that a tenant could then use, submit to their landlord in order to basically get the clock running on this the safe harbor period. So again, 60 days if you're outside of Multnomah County, 90 days if you're within Multnomah County. And so again, the key takeaway here is that tenants should be applying for rental assistance as soon as possible if they're not able to pay their rent from July 1st onward. So when can tenants request that 60 or 90-day pause? So, this is going to depend essentially on, where you are in the eviction process. If you submit it to the landlord before a termination notice has been issued, that is an option. The landlord cannot then give you a termination notice or file an eviction case for at least 60 or 90 days, depending on where you're located. If you give them the proof of rental assistance after the termination notice has been served, but before the eviction case has been filed, the landlord cannot file an eviction case for at least 60 to 90 days. After the pause, the landlord must give the tenant a new 10-day termination notice in order to, if they want to proceed with evicting the tenant for not paying rent, if they haven't received the rental assistance payment by them, of course. And then basically the last opportunity that tenants have is, after the eviction case has been filed up until the end of first appearance. So if they submit it to the landlord then the eviction case is essentially postponed for 60 to 90 days and it resumes after the pause. Some landlords have been generous and have been submitting like motions to dismiss the case outright, which is great. But unfortunately, in some other cases, basically what the judge is doing is just kind of like, setting aside that first appearance hearing for at least 60 or 90 days in the future. And the reason that I say that some landlords are being generous is because essentially if they were to dismiss the case, in some cases that would require that they go back and refile an eviction case against the tenant, which would just buy them a little bit more time. And as Diane mentioned, there's also some new requirements that landlords need to adhere to if they are going to issue a tenant termination notice for non-payment of rent. So essentially, when the tenant is being issued this kind of termination notice, the first thing I want to note about this is many of you probably know what a 72-hour notice is, right? I mean, before the pandemic started, that was essentially a landlord's way of terminating somebody for not paying their rent. And all it meant is that a tenant had 3 days essentially to pay back the rent that the landlord alleged that they owed. And if they didn't pay it back within those 72 hours, and they didn't vacate at the end of that 72-hour period, they could then have an eviction case filed against them. But now, because of these new tenant protections, landlords are now obligated to provide the tenants with 10 days of notice. So essentially what this means is that the tenant now has 10 days to pay back the rent or 10 days to move. And if neither of those two things happens by the end of the 10 days, the landlord can then go and file an eviction case against the court. But the landlord's not only required to provide the 10-day notice, they're also required to include 3 pieces of documentation with that termination notice. The first of these is a notice of the tenant's rights under Senate Bill 278. So again, the safe harbor law essentially. So essentially it's just letting them know, hey, you have this option to submit to me rental assistance, proof of a rental assistance application. And then once I get that, I'm going to have to put a 60 to 90-day pause on eviction proceedings, essentially. The second piece of documentation they need to provide is a statement that eviction for non-payment of rent from the emergency period, any rent that accrued during the emergency period, is not allowed before February 28th, 2022. So again, this is essentially just telling tenants that they have protections under Senate Bill 282, which, as Diane previously mentioned, just extends that grace period for tenants to pay back any rent that accrued during the emergency period. So that bubbled in area in the calendar that Diane created. And then the last piece of documentation that the landlord needs to include with these termination notices is a statement just with information regarding tenants' resources that a tenant could access. One of the things that they're required to include is information about 211. They could potentially include information about other sources of rental assistance or tenant support. But yeah, at the very least, they need to include the 211 info so that tenants know that they can access resources for rental assistance. And if the landlord fails to do any of these things, the court essentially needs to throw out the pending eviction case of a termination, or if an eviction case is filed based off faulty termination notice that either didn't provide 10 days or didn't include the notice of the tenant's rights under Senate Bill 287 or 278 or 282, or it didn't include information about tenant resources. So if any of those things are missing, or the tenant does, or the landlord doesn't provide enough time on the notice, then the court needs to throw it out because that's a defective notice. It can't be filed. So penalties for violations. So if the landlord violates the grace period protections or other provisions of Senate Bill 282, or if the landlord does not honor the 60-day pause or 90 days if you're located within Multnomah County, then the tenant may have a defense to the eviction, and they have a right to, basically get a court order allowing them to return to the home. So this would usually come up in a situation where, they've been unlawfully locked out or something like that after the termination notice is expired. I also want to just quickly note that that's illegal to begin with. A landlord cannot evict until they have a court order from the judge, and even then, the landlord can't be the one to forcefully remove somebody or lock them out. It would be something that law enforcement would need to do after getting a court order from the judge saying that they can do that. If a landlord unlawfully evicts a tenant, though, or locks a tenant out or shuts off the utilities in an effort to kick them, to force them out of the home, the tenant likewise can obtain a court order to be let back into the house or to have the utilities turned back on. So that's what we know as injunctive relief, essentially. So those are the two remedies. Unfortunately, there are no monetary damages under either of these two pieces of legislation, which is a bummer, but at the very least, folks are protected from eviction under these circumstances. So.
Okay, so moving from the state and the local legislation at the, well, this isn't really legislation, but at the federal level, there is the CDC order by the Center for Disease and Control.
Sorry.
Whatever the acronym is, I think folks have heard of it now.
No, I think that's right.
In any event, that order has been extended until October 3rd of 2021. What it does is it bars actual evictions, which is the physical act of the tenant being removed from the home. It does not prohibit the landlord, unlike the state and the local laws that we just talked about. It does not prohibit the landlord from actually issuing the termination notice or filing an eviction case. It also, to get protection under the CDC order, the tenant would need to sign, they are required to sign a tenant declaration. So they're stating under penalties of perjury that they have applied for government assistance and that they are income eligible. On the tenant declaration form, there's certain boxes that lays out how you can identify whether or not you are income eligible. And third, they must also declare under penalties of perjury that they live in a county that's experiencing substantial or high COVID-19 infection rates, which as we see from this screen capture that I pulled yesterday, and I believe is current up to August 23rd, that's most of the country, except for Nebraska, which might raise questions about what kind of data Nebraska is reporting, whether they're reliable. In any event, for Oregon tenants, for most Oregon tenants, I mean, we want to put this out here to explain it to folks because folks might be more aware of, heard of the CDC order, but it's actually important to note that for most Oregon renters, in most situations, they get more protection under the state laws. So just if they apply for rent assistance and they enact or they initiate that 60 or 90-day pause, it's just gonna get more protection to CDC order, right? We're at the end of August, and this extends to August 3rd of 2021, which by my quick math is about 30 something days, where in comparison, you can initiate a 60-day pause or a 90-day pause, depending on where you are. And included there is also 2 links for where folks, if they are in a situation where the CDC declaration will provide them more protection, they can find it, the link that's provided there, and it's available in multiple languages other than just English. And then on that third point about the tenant declaration the tenant needing to declare that they live in an area that is experiencing substantial or high COVID-19 infection rates, they can use that CDC COVID data tracker link in order to identify whether or not they are in that qualifying area. Okay, and we had mentioned that under Senate Bill 282, the state legislature had also provided additional protections that's not directly related to non-payment of rent or owed rent. But so we'll go over what these are. So until March 1st of 2022, landlords may not charge late fees for non-payment balance that accrued during the emergency time period. Again, April 1st, 2020 to June 30th of 2021. Additionally, they cannot assess fees or terminate tenancies based solely on the presence of guests in the unit. So a tenant might have a rental agreement that provides that there's a guest policy and your guests cannot stay within your unit for more than however many days within whatever time period. For example, more than 15 days within a 12-month time period. Well, that is not during this time period, not enforceable, a reason for the landlord to evict Okay, I'm gonna kind of fly through some of these other things. Thankfully, this is available as a slide and you'll have this recorded, so you can just pull this up at your leisure to kind of review more of this. But so one things to note here is that if you have guests in your unit, right, because folks are doubling up because times are difficult right now, know that you might have some protections. Landlords can't evict solely because you have a guest, although you must still comply with other applicable laws. The landlord may require that the guest satisfy screening or admissions criteria, although they cannot require that the they cannot screen the guest for the credit history. Additionally, until January 2nd of 2028, landlords may not deny an application for tenancy because of any eviction judgment. That means not only the non-payment types, but any type for cause included. If that the claims had arose between April 1st of 2020 and March 1st of 2022. So that's protections for the eviction history. The thing to note also, as we'll discuss later, is a lot of these eviction judgments during this emergency time period may be immediately eligible for expungement. And lastly is that during the eviction screening process, I'm noticing now that those arrows don't exactly line up with the bullet points, but go with it here with me. Okay, application screening process. During the screening process, a landlord cannot deny an application for tenancy because of any unpaid rent that had accrued during the emergency time period. Lastly, landlords may not report the non-payment balance that had accrued during the emergency time period to a credit agency.
Awesome. So yeah, that was basically our overview on the COVID-19 tenant protections. If folks have questions about this, I believe that this is going to be posted on YouTube once this live stream ends. So, you know, definitely feel free to leave questions and stuff like that. I think that I'll definitely be checking just to see what viewership's like afterward and checking for comments and questions as well.
No promises here.
And just trying to address those to the extent that I'm able. We're not able to provide legal advice unless you're a client of ours, but you know, generalized questions are totally fine. I'd be happy to try to answer those. So now we're going to move on to eviction expungements. So as Diane mentioned, this has become really important. I mean, it was already important to begin with. It's a great tool for tenants to use, but it's become especially important in light of the passage of Senate Bill 282, which again provides that landlords up until January of 2028 cannot be considering eviction judgments that arose during the emergency period. And it also automatically makes those types of eviction judgments that occurred during the emergency period eligible for immediate expungement. So yeah, now I'm just going to go into the process. So first and foremost, what is an expungement? Many of you guys probably know this definition, but just to make sure, it's basically an eviction record that gets erased. Some of the legal jargon is like set aside or gets sealed, but basically it's just erasing an eviction judgment so that nobody can ever see it again. So again, prospective landlords cannot search for that record when they're screening a tenant for possible residency at a property that they manage. And then a tenant can safely answer no when they're asked whether an eviction ever occurred during that screening process. So as you guys have probably seen in application forms, it's usually going to ask you that question. If you've had your eviction record expunged, you can safely put nope, and they're not going to be able to see it until there was ever an eviction in the past. It's an important tool again, because a lot of landlords do tend to try to circumvent some of the prohibitions under the law, and they'll consider eviction records that they shouldn't be considering. So this just ensures that those are never visible and that they can never be considered. So in order for a tenant to be, or in order for an eviction record to be eligible for expungement, one of four things need to be true. So the first of these is the judgment of restitution, or the eviction judgment needs to be at least 5 years old, and the tenant needs to have paid all money owed under that judgment. So it's not uncommon for judges to include in the eviction judgment that a tenant needs to pay things like the opposing party's attorney's fees or court costs. So, as long as that's been paid off, that eviction judgment, as long as it's 5 years old, can be expunged. If there's a judgment by stipulation, meaning that the landlord and the tenant came to an agreement in court and filed that with the court as part of the eviction case, and as long as the tenant complied with all the terms of that agreement, the case has been dismissed, then that record would be eligible for expungement as well. If there's a judgment in the tenant's favor, so usually that's known as a judgment of dismissal, of general dismissal, then that's automatically eligible for expungement as well. And then because of Senate Bill 282, any basis for eviction that arose between April 1st of 2020 and February 28th of 2022. Any eviction judgment in that time period is automatically eligible for expungement as long as the tenant has paid any money owed under the eviction judgment. And then in terms of steps, so like, as Diane mentioned, this is a fairly basic process. It just involves three quick steps essentially. So the first of these is that the tenant needs to fill out and file what's known as a motion to set aside a residential eviction judgment form in the county where the eviction happened. So for the Multnomah County, you would file it there, Clackamas County, likewise, so on and so forth. One big thing that I want to note is that this is a free process. There is no filing fee that you need to pay in order to file this motion. It is completely free. I should also note that each tenant in the eviction case must file their own expungement request. So if you had tenants that were included in that, or sorry, co-tenants or roommates that were included in that eviction case, in that judgment, they need to file their own request for expungement. Otherwise, it would still show up for them and potentially for you as well if they search under your co-tenants' names. The second step is that the tenant serves a copy of that motion to the landlord in the eviction case so that they know that they're seeking expungement. And then basically once that's happened, the court gives the landlord 30 days from the date of service to basically file a written objection to the expungement if they feel that the tenant shouldn't, if that eviction record shouldn't be expunged for some reason. If the landlord does file a written objection, the court then would schedule a hearing to decide whether the tenant is eligible for expungement. But if the landlord does not object within those 30 days or just doesn't respond at all, then the court automatically will rule on whether or not the record is expungible. If they rule that it is, it automatically gets raised. It will never be visible. And so here on this slide, we just have just a screenshot of the motion for expungement. So fairly basic form, only a page and a half long. So again, you just basically fill out the information of the eviction case that you're wanting expunged. So who is the landlord, the tenants included in that judgment, the case number, your specific name, and then you just have to, on the check boxes below at the bottom of that first page, you just need to check off how the eviction record is eligible for expungement. You then need to just sign off saying that all the information included is true to the best of your knowledge, and then there's a certificate of mailing just certifying. If you decide to serve the landlord via mail, then you did so. You file that with the court just to verify that you served it.
Okay, as we're wrapping up here, we want to note for folks that as tenants, you have rights and resources are available. And one of the best resources here is OregonRentersRights.com. That is a website that is managed and updated by our organization and our sister organization, the Oregon Law Center, where we provide a lot of self-help guides and information for renters. They're not replacements for legal advice, but I think it's a good starting point for tenants as they questions arise, and just having written materials to be able to sit down and digest information is, I think, is really beneficial. These are just next few slides here is just going to be screen captures so that we can just kind of run through and let folks know what are some of the samples of the materials that's available. Versus when you go to that website on that landing page, you're going to see that big red button at the top, or at the top of that page, but at the bottom of my slide here. And then click here for coronavirus COVID-19 emergency protections for renters. A lot of information that we just covered, you will find when you click on that link. As of this morning, it has not been updated yet with some new resources that have just recently become available, including a one-pager to cover the information that we just discussed. And it's available in, other than English, 10 other languages, including Vietnamese, Russian, Somali, Chinese, Arabic, and a few Pacific Islander languages. So I just want to note for folks that at least as of this morning, it has not been updated yet, but those resources are available. So don't hesitate to contact your local legal aid office if you're in need of those. And then if you're in community with folks who are limited with English proficiency and could really use this information, just want to highlight it's available and folks can share resources with each other. Additionally, one of the resources that we have is a handbook on hostile living environment. So that what that addresses and what when folks might be interested or might want to take a look at that is if you are facing what seems like discrimination based on a protected status. So protected status under federal and state housing law includes discrimination based on your race, gender, color, national origin, religion, sex, family status, disability, and source of income for under Oregon law. So that packet gives you a little more information and guides you on how, as with the rest of the packets that we'll discuss, it'll guide you on how best to keep a paper trail to document the incidents that have happened in order for you to best be able to access any legal remedies that might be available.
And then in addition to that, the handbooks that Diane just mentioned, we also have handbooks on reasonable accommodations if you're a person with a disability and you feel like you need a modification in your home so that you can, enjoy the housing to the fullest extent possible. You have the right under federal fair housing law to submit a reasonable accommodation request to your landlord to either, have a modification applied or made to your dwelling unit or the right to request an accommodation so that the landlord makes, an exception to, general policies that they may have, and so on and so forth. So that's one right. And as Diane mentioned, included in that handbook are sample letters that a tenant could use if they wanted to submit a reasonable accommodation request to their landlord. It also includes verification letters, sample verification letter for qualified third parties. So just so folks are aware, generally when you submit a reasonable accommodation request, it's not required that you include verification of your disability, but it is possible that the landlord may request that. They have the right to do so, and if they do, there's that sample letter there for you to present to the qualified third party that you want to provide verification. We also created a guide on eviction expungements, which just details all the steps that I went through and includes the sample of the motion for expungement. We also have a guide on security deposits, which, I think that basically is pretty self-explanatory. And then lastly, we have guides on applications and tenant screening. So there are various protections, especially in the city of Portland, for tenants during the screening process, during the application process. So yeah, take a look at those, come informed about those.
All right, more things for you to take a look at. Are you dealing with mold issues? Are you dealing with pest infestations, bed bugs, roaches? We have resources available for you to dig into what your rights are related to those issues and how you can best protect your rights and assert those rights and get legal remedies if your landlord isn't being responsive to those issues, because you have a right as a tenant to what's called a habitable living condition. So that's be a livable, safe living condition. Additionally, there is a handbook on relocation assistance. If you are in the city of Portland, you have additional rights when a landlord issues you a no cause termination notice, or if they raise your rent. You might be entitled to relocation assistance. So take a look at that handbook if you're a renter in the city of Portland and find out if it applies to you and you're entitled to some money. Lastly, there's a repairs handbook. Similar to the mold infestation issues, is the landlord is required to keep your unit in a safe and habitable living condition. If they are not responding to your, it's important first is they can't respond to repairs requests if you have not told them about a problem. So there are sample letters in the repairs handbook that takes you through the process of what kind of language you want to use to assert those rights, to let your landlord know of the issue, and guides on how to protect yourself and document the sort of repairs that needs to be done in order to create that paper trail in the event that you would need to pursue the matter in court if necessary to get the repairs done.
Some more information. It's a ton of stuff that we have on there, so please go check it out. That's the main takeaway here. We have a handbook on the small claims court process. There are cases in which a tenant may not be able to find representation, but it might not be necessary for them to find representation. So generally, in the state of Oregon, if you have a claim against somebody that doesn't exceed $10,000, you can go and file a small claims lawsuit. Essentially, you're not allowed to have representation unless you meet certain exceptions there. So generally, both parties are going to be unrepresented. So yeah, this is a place where you could go to file claims for a landlord's failure to provide you with to refund you your security deposit, to complete repairs, so on and so forth. We have a handbook on the rights for tenants in manufactured home parks, a handbook on what tenants should do if they're facing a lockout or an unlawful ouster. So an unlawful ouster is basically, it could either mean a lockout or it could mean that a landlord has shut off your utilities or done something else essentially to try to force you out of the home. And then lastly, we have a pretty handy guide on termination notices and the eviction process. It's pretty lengthy, but if you're one of the tenants facing termination or eviction, check it out. It's got some pretty detailed, just instructions on your rights and what you can do during the eviction process to assert your rights.
All right, thank you. Thank
Yeah,
you to
thank you.
Doshi Portland for the space today to present to folks.
Yeah, and I want to echo those sentiments. Thank you